Please be seated. The court is now back in session. I hand over to the defense team for Mr. Nguyen Chia to continue his line of questioning. You may proceed.
សូមអរគុណលោកប្រធានខ្ញុំនៅមានសំណួរតែពីរ3ទៀតអស់ហើយនឹងបន្ទាប់ទៅនេះសហភិតាខ្ញុំនឹងបន្តលោកសាក់សីខ្ញុំសូមសួរលោកបន្តតែពីរ3សំណួរទៀតទេ
I have only the last few questions to ask to this witness before I hand it over to my esteemed colleagues. I would like to now refer to document E3/64, your written record of interview with the OCIJ. The question asked you at that time was who Jaim and Duen were, and you said you did not know for sure. You said that Jaim could have been members of the assembly and Duen could have been the chairman of any one offices with Mr. Kieu Sampon or Mr. Nguyen Chia, or he could have been a chairman of the North Zone Committee. And you used the word could have been. It implies that you were not sure. It was your assumptions that that was the case. Is that a fair summary of that statement? It was your assumptions of the position they held.
បាទខ្ញុំបានឆ្លើយយ៉ាងដូច្នោះមែន
Response: Yes, at that time I used the word they could have been, and I also used the word perhaps as well, because I was not sure. But when I came to testify before this chamber, I learned that the word that the testimony that I was not clear, was not sure, was not used by the court. So I would like to request the court to remove the word and that I used the word perhaps it could have been or so. I would like them to be removed, the words according to my assumption or so. I would like to remove all the paragraph and statements which I only make inference or so to any event. Counsel, thank you very much for clarifying this, and this is the second time that you have mentioned about this issue. Now I would like to stay on this particular written record of interview. At that time, the OCIJ asked you what Nguyen Chia had to do with this telegram, and then you told them that that telegram was meant to be sent solely to Pol Pot, but then the telegram unit learned that this telegram was supposed to be sent to people who were in charge of addressing problems with the publics and people, and Nguyen Chia was responsible for that at that time. And according to your statement, you said the order was, or the telegram was to be sent to the person who was in charge of the people, and Nguyen Chia was in charge of the people. Can you enlighten the court on this? Because Nguyen Chia at that time was the chairman of the People's Assembly, and why was Nguyen Chia a responsible person for the people? Because he was merely the president or chairman of the People's Assembly back then. Response: frankly, I did not know the detail of the management handled by Bond. But at that time, the investigator of the OCIJ asked me to have analyzed the situation and explain what happened. So at that time, I explained that it could have been this or it could have been that. So at this particular juncture, I also said again that it was not under my responsibility, and neither was it within the assigned task I had to handle. And in that particular message, there was an instruction clearly there that it was to be sent to Brother Paul. But when we screened through the content of the message, we learned that it was not meant for Brother Paul alone, but the potential recipient could be many. That's what I told the investigator of the OCIJ then. So that's why the telegram unit produced annotations that it was to be sent to Brother Nguyen. But actually, they came to the decision that this telegram had to be sent to Brother Nguyen. And at that time, that was my explanation. That's all I can clarify on this particular point. Counsel, now I am coming to my last question for you. Yesterday, the lawyer for the civil parties asked you that if anyone committed any wrongdoing or moral misconduct in their daily life, what happened to them. And you, in response to this question before the OCIJ, said that if anyone committed any immoral conduct, that matter was referred to Mr. Nguyen Chie. My blunt questions for you: why should it be under the responsibility of Nguyen Chie? Because Nguyen Chie was the chairman of the People's Assembly. He had nothing to do with these kinds of things. Witness, I would like you to look at this statement again. If I mention anywhere in my statement that it could have been, so it was my assumption. The President interrupts. President, prosecutor, you may proceed.
Your Honour, 2 points of order. First of all, counsel is referring to portions of the statement and references to exhibits. He should provide the correct exact ERNs and document numbers so we can all follow. Secondly, I didn't object the first time, but I will object now. My learned friend is misrepresenting his client's positions during the period. I believe his client has himself accepted that he held the position of Deputy Secretary of the CPK. To be putting to the witness a proposition that is simply not true is improper, and it leads to confusion and potentially incorrect evidence being adduced. So I would just say on that second point, if my friend wishes to put to the witness his client's positions, then he should state them in full and not misrepresent that Nguyen Chie was merely the President of the People's Representative Assembly, because that is not the case.
Counsel Sonoran, I would like to respond to my learned colleagues from the prosecution. I did mention the document number, and there was no objection when I mentioned this document number and when I started my question concerning this document. And in my first and second questions, I did mention that I refer to the same document, but the difference were the questions. And the witness did enlighten us on the question I asked. But the very last question I asked, the witness simply wanted to double check whether or not he had used the word could have been, or perhaps also that he was not sure about that situation. That was all actually, and there is nothing else, and that is all for me as well. President, International Counsel for Mr. Nguyen Chia, do you have any questions to put to the witness? If so, please proceed.
Thank you, Mr. President. Good afternoon, everyone. Good afternoon, Mr. Witness. I do have some questions. Mr. Witness, good afternoon. I, along with Major Sanarun, the gentleman who just asked you questions, I represent Nguyen Chia. I have some further questions I'd like to put to you. And before I do that, just let me begin by thanking you. I'd like to thank you not only for coming here to answer all of these questions. I know it's been a long time, it's been a hard task, but also I'd like to thank you for telling us, as you've done so many times since you've been here, over and over in fact, if and when you don't know something, when you don't know the answer to a particular question. And just let me say that we're grateful for that kind of candor. Now, if I could just start with something which hopefully will save me some time and allow me to finish today so I don't have to continue into tomorrow. I'd just like to confirm one or two things with you. And I'm doing this only so that I can properly understand your evidence and so that it's very clear for me on the record. So first of all, you've told us that although there was a system in place at the base level, and in particular at the zones, I think you said, to confirm the receipt of telegrams once they'd been sent out from K-18, I believe, you yourself told us that you could not confirm whether those telegrams were actually, that were actually sent, were always received. And I just want to make sure I have that correct, that you yourself were not in a position to confirm whether all the telegrams that were sent out were received. Have I got you right?
Yes, that is correct. I was not in that position because it was beyond my ability that I had to follow up with that.
Thank you very much, Mr. Witness. And something else which I believe you told us was beyond your ability, and I'm asking now so that I can confirm it. And this is something you said this morning in response to a question by my colleague on my right, Mr. Kong Sam On for the Q Sampan team. I believe what you told him was that in actual fact, you didn't know whether any of the telegrams that you dealt with reached their intended recipients. You didn't know that for a fact. You can't confirm that. Did I get you right on that point? You didn't know whether telegrams actually reached their intended recipients, in particular those people whose names were on the telegrams. Is that correct?
Yes, that is correct. I was not sure whether or not those telegrams reached all of them.
Thank you. And just one last question on this point, just to be crystal clear, as my friend across the stage would say. Is it fair to say that the outer limit of your field of knowledge, that is, the things that you yourself would personally know about, with respect to those telegrams you told us about that were placed in envelopes that were labeled K1, is it fair to say that the outer limit of your knowledge as to the fate of those telegrams was that guard booth or that box that you described in front of K1 on several occasions? Is that correct?
បាទមិនមែន
No, it was not in the envelopes placed at the gate of K1, but all the messages had to go through this gate where there was a guarding post to receive the incoming letters or so. So we had to go through that. So we did not send it in the envelopes through post or so, but it was actually sent to K1, and there was people who were standing guarding the premise who convey this letter to others.
So just so I understand you clearly, those envelopes that you described, which were labeled K1, they were deposited or dropped off outside of K1, and then somebody else took it from there. Is that correct?
Yes, there were people guarding 24 hours around the clock at the guard post right in front of the main building.
Thank you, Mr. Witness. And so what actually happened to those telegrams beyond that box, that was, as I believe you've told us, solely Pon's domain and not your own business. Do I have you correct?
The guards at K1 would convey the letters to Pon, and Pon was the one who continued to circulate these letters.
Thank you, Mr. Witness. That, I believe, will save me a great deal of time. Let me move on to one a general item, and then we'll eventually return to some additional specific matters. My colleague, Major Sanaroon, asked you some questions, or asked you a question already about those assumptions you referred to, and you gave us a very clear answer on how you thought the Chamber should deal with those assumptions that you made to the OCIJ investigators. I'd like to ask you another question, a different question, about something you said about your time with those OCIJ investigators. And I think it's probably easier if I just quote from the draft transcript so I don't misstate or mischaracterize what you've said. And this was from yesterday's evidence. And I believe this is something that you said to one of the civil party lawyers. And I'm quoting now from the draft transcript. That's Tuesday, 4th of September, page 53, line 7. And you said, at the time, I did not know when these people disappeared or were removed, you said. The investigators tried to ask me this question time and again. I already stated very early that I did not know from the beginning. First, he asked me to explain about the removal of people, and I started to explain on this. But then more and more questions were bombarded on me, on Pong and Tay. And the statement, and indeed the statement, could not be used as the evidence because, as I said, I didn't know. And I do not know what happened to the removal of people at the base. I do not know how this worked. Now, what I'm interested in is a phrase that you used in that bit of testimony. You mentioned that you were bombarded somehow by the investigators. What did you mean by that? Did you mean to say that at times during the time you spent with the investigators, when you didn't know something, or when you made it clear that you didn't know something, that those investigators continued to press you with questions because they weren't satisfied with your answer? Or did you mean something else? Maybe you could explain to us what you meant by the bombardment passage. And Mr. Witness, please don't answer it yet. My colleague is on his feet across the stage.
Your Honours.
The President, witness, please hold on. And Mr. Prosecutor, you may proceed.
Your Honours, I'm reluctant to interrupt my learned friend's examination, but we would object on the basis of relevance. We've heard the first-hand evidence from the witness. We've heard his explanations as to the limits of his knowledge. We've heard his clarifications. We've also heard him confirm numerous parts of his statements, and we've heard him provide clarification where clarification is necessary. We would submit that questions that go to the techniques adopted by the investigators in this instance are simply irrelevant. If my learned friend wishes to test the witness's knowledge by reference to the prior statement, ask what he meant in that statement and how that differs from what he says today, that's entirely appropriate. But questions about techniques and questions asked in an OCIJ interview are irrelevant. We have the witness here and we can deal with the facts with the witness.
If I may just briefly respond, obviously I take a completely different position. It has long been our position that those very techniques that the investigators used during the investigation, the propriety of those techniques, the substance of those techniques, the style of those, all those things, as we've said time and again, are relevant to the question of the quality of the evidence that is now put before your chamber in terms of these witness statements, many of which, based on your rulings, we are going to be relying on in some form or another without calling witnesses, without adversarial testing. So it is our firm position that these techniques are clearly relevant. They're relevant to the quality of the OCIJ investigation. And I think this witness, he's here, he's sitting with us, he's told us about a bombardment. I think he can very easily tell us what he meant by that. It could be that it's completely innocuous, and he would be the one to tell us.
Good afternoon, Mr. President. Good afternoon, Your Honors, and good afternoon to everyone in and around the courtroom. I wish to support the response provided by counsel for Nguyen Chia and wish to add the following. These events happened nearly 40 years ago. How the investigation was conducted in taking the summary, what was done in that process to assist the gentleman in remembering events, showing him documents that may have refreshed or created memory. These sorts of techniques are the sort of areas that we are entitled to explore because it goes to the credibility of the witness's actual memory and his understanding of the events at the time when they occurred with the knowledge that he had at that time and not the knowledge that he may have been provided by the investigators. This is a line of questioning that was pursued in the past. Obviously, the prosecution would like to have any inappropriate conduct related to investigations not be explored for all the obvious reasons. We think this is an absolute necessary process. It's done before all the other tribunals. We're using international standards. There's no reason why we should not be able to use these same standards in this courtroom here. Thank you.
President, the Defense Counsel, you may proceed.
Very briefly, Mr. President, I wish to lend my support to the comments made by my learned friends on this side of the chamber. In a trial of this case, it is important to have rules. Rules of honesty, rules of integrity, rules regarding a technical questioning of witnesses, as we've already seen here in this case and in the past. if we are to rely on the written record of witness interviews produced by the co-investigators who may have interviewed this gentleman prior to the 18th of February, and there's no record or recording of the interview, this is something that should be raised with the witness. This is of paramount importance, and I therefore fully support the request and application that has been forwarded by my learned friend.
Do you stand on your feet on the same matter, or do you have an additional matter to raise, counsel? Do you need to continue to put questions to the witness, or you need just to take the floor to reply to one another?
I was just about to explain that. What I was about to say was, with your leave, I would like to add one very brief additional point, and I promise not to make a habit of this, but I think something that needs to be said is this sense that we're dealing with a cured investigation, that the closing order cured the faults, any faults there may have been in the investigation. We've been here for almost a year now, and I think we can all point to numerous occasions of what I will call irregularities, where statements don't match. We get audio recordings that are off by several hours. I think we've passed the point of rebutting any presumption of regularity that attaches to the judicial investigation, and I think that's a point that needs to be made. These are serious issues. We can't test all this evidence. We don't have time. This was one of the things that was one of the main topics at the trial management meetings, that we're running out of time. We don't have time to test this evidence. Even today, the point I raised this morning, we get a transcript of a witness statement who's been on the stand for 3 days after he's been on the stand for 3 days. So these things are happening after the fact on a very ad hoc basis, and I just want to make it clear that I don't think this chamber should attach any presumption of regularity to the OCIJ's investigation. And I apologize for not saying that the first time. As I said, I won't make a habit of adding comments at the end.
President, first, let me remind you that the chamber has observed the frequency of this objection and replied. If I'm not mistaken, you should refer to the declaration by the chamber to the witness of his right and obligation that he must tell the truth, that he have heard, have learned, have known, and have experienced or observed regarding the events related to the questions put to him by the chamber or any of the parties. That is the duty of the chamber to inform the witness. And even if there is no objection, the chamber already informed the witness that they cannot make a presumption or a conclusion, as the witness is not an expert who can make a conclusive statement based on the expertise. You also said it is important, and of course the chamber already repeated that point and stressed it once again, that counsel should put your request in writing to represent all those aspects, so that the chamber would have the ground to decide on your submission regarding a particular matter, and that we can rule on that. As you understand, there are millions of pages of document in the case file. It is very difficult to categorize all the documents into its specific category. Even up to today, there's still new issues arising out of the document issues. And we are facing the same issue again today. And you said that it is a very serious matter. And when it is objected by the prosecution, you raise it is a serious matter. And if you know it is a serious matter, then please put your submission in writing to the chamber so that the chamber can deliberate on your submission and rule on it.
Thank you for that clarification, Mr. President. Am I to understand that I should be putting replies to objections in writing? Is that what you've just told me? I asked a question. The prosecution objected on the grounds of relevance. I stood up to respond or to reply, to tell the chamber why I thought it was relevant.
We will rule on this objection now. We will not put this witness in a waiting while we are debating this issue. But you took the opportunity to raise that it's a very serious issue and it's been going on for a long time. That is the point that I'd like to stress. And if you think it is of great importance and that it happens regularly, then you should put it in as a submission in writing, stating your grounds for it.
Thank you again for that clarification. Are you... Oh, sorry.
President, in order to rule on the matter at hand, I'd like to give the floor to Judge Lavange to respond to this matter. As for the defense counsel who puts question to this witness, please try to slow down so that we will have an accurate record of the question as well as an accurate interpretation. Judge Lavange, you may proceed.
Oui, merci, Monsieur le Président.
Thank you, Mr. President. The Chamber would like to point out that it is seized of a number of motions questioning the interrogative techniques used. And it is important that issues raised at trial should be raised openly without containing in themselves allegations according to which the co-investigating judges' investigations have been dishonest or fraudulent. I think that at this stage in the proceedings, such allegations are inappropriate, so you are invited to ask questions that do not contain such insinuations. In other words, your questions should be open. I think that is the most important point that we wanted to make.
Thank you for that clarification, Judge Lauren. I'd just like to add for the record, and I will speak very slowly. In my submission, I made a very measured submission, and I suggested that the answer from the witness could be an innocuous one. So I do take exception with the fact that I have impugned anyone's integrity ad hominem. I have not done that. I haven't named anyone by name. I haven't said this investigator is a bad person, the one who took that statement. I haven't said anything of the kind. So I do take exception to that ruling, just for the record. Just for the record. But I do note what you've said, and may I continue with, may the witness answer this question, or has the objection been ruled on?
You may continue putting questions to the witness.
Thank you. Mr. Witness, coming back to what I said previously, I have the same question for you. What did you mean when you said that you felt you were bombarded by the OCIJ or the investigators? Could you please tell us what you meant by that? And please correct me if I'm misquoting you in any way, if that's not what you've said.
The situation was that regarding Pong and Tay, in my statement, I stated that I didn't know where they went, and they still insisted on asking who disappeared first. And it was very difficult for me to respond. That was the situation. Because I said I already did not know, but they still insisted on asking me further questions, that who was removed first. That was the situation, I repeat.
Thank you, Mr. Witness. So just so I have that clear, after you gave what you considered to be a clear answer to the OCIJ investigators, not calling for any further questioning on that point, they continued to question you and ask you questions that suggested that you may or should know those things. Have I got you right?
President, witness, Please wait. Judge Lavange, you may proceed.
Maître Yanouzi, je pense que
Mr. Yanouzi, either we have a communication problem or you are not making an effort to understand us. What we are telling you is that you should ask open questions. And in one of your questions, you suggested that the questions were unfair. That point is quite simple to understand. You are suggesting to the witness that the manner in which he was questioned was tantamount to dishonesty.
Your Honor, it was the witness's answer that suggested that, and I was following up on the answer. That's all I was doing. That's what the witness said.
Maître Yanouzi, je ne pense qu'on n'est
Mr. Yanouzi, I do not think we are here to comment on the Chamber's ruling on objections. You are here to follow the instructions meted out to you by the Chamber.
Well, in that case, just so I clearly understand the instruction that was just meted out, I am not permitted to ask, I must ask an open question even when the answer from the witness is highly suggestive. Is that the ruling? Just so I have it clear, I don't want to offend you anymore.
Judge Lavange, you may proceed.
Je crois qu'il ne faudrait peut-être pas surinterpréter.
I think we should not overinterpret the witnesses' responses. We should show proof of fair conduct before the Chamber.
Thank you, Judge Laverne. I'll move on to my next question on the same topic. Mr. Witness, one of the first things you did in this courtroom when you appeared on Wednesday of last week, I believe it was, you confirmed, in response to a question from the President, the content in its entirety of both of your statements to the OCIJ investigators. Do you recall that?
I do not understand your question. Can you rephrase it?
Certainly. As I recall, one of the first, let me take it step by step. Do you remember your first day of testimony before the Chamber? That was last Wednesday. That is Wednesday of last week. I'm sorry, Mr. Witness. I can rephrase it again if you're still unclear.
I am unsure because there were a lot of questions when I was first appeared on Wednesday. What question are you referring to? I responded to various questions, but I cannot recollect all of those questions and responses.
Indeed, Mr. Witness, you are correct, and it's late in the day, and I apologize for my lack of clarity. The very first individual who put questions to you was the President of the Chamber. Do you remember that?
Yes, I remember that.
Thank you. And do you remember, as I recall, and tell me if I'm wrong, one of the questions he asked you was whether or not you had reviewed the two statements you gave to the OCIJ investigators pursuant to the normal policy in this court whereby witnesses are given their statements to review in advance of testimony.
Yes, the President asked me that question.
បាទឲ្យខ្ញុំពិនិត្យចឹង
And of course, I reviewed the statements. And the statements were consistent.
Thank you. And then I believe, as a follow-up question, he asked you if you confirmed the contents of those statements in their entirety, if you stood by what you had said completely in those statements. And as I recall, you said yes, but please correct me if I'm wrong.
Yes, that is correct.
Thank you, Mr. Witness. Now, again, at several points over the course of your testimony, over these last few days, you have, and I'm not going to characterize this in any way, so let me just say, at times you've said that certain portions of your statements should not be relied upon, should not be used in evidence. And I believe you very clearly indicated that those portions related to places where you felt you had made assumptions. Is that correct?
បាទ
Yes, I repeatedly state that please review my interview with the OCIJ investigators. As for the text where I made a presumption, please don't use that portion as a true and reliable statement. Please disregard that portion.
Thank you, Mr. Witness. And correct me if I'm wrong. Is that because the President of the Chamber explained to you what it meant to make assumptions, what it meant to use qualified language, like perhaps, like maybe? Is that why you made those later statements? Because the Chamber explained what it meant to make an assumption?
Yes, the President reminded me, I think from my recollection, immediately after the morning session started, he reminded me to give my best effort in providing a truthful answer and without providing any answer based on my presumption.
Thank you, Mr. Witness. And maybe this could be my last question for the day. When you gave those statements to the OCIJ, did anyone who was there taking the statement explain to you or tell you not to make assumptions?
There was no clear explanation as the President did. However, I was told to speak about the truth or what I knew clearly or the experience that I went through. I was reminded of all these points before the interview started.
Thank you, Mr. Witness. Your Honor, I don't mean to be presumptuous myself, but is this a good time to stop? I'm not finished. I would like to continue tomorrow.
President. Thank you, Council. We shall adjourn now, and we can resume tomorrow. Council, you are also reminded to read and review Internal Rule 76, rather 76, Sub-Rule 7, which clearly states, according to the civil law systems, besides the subject of the appeal, the amendment shall be made pursuant to the rule of questioning, and no such procedural defect can be raised before the trial chamber or during the court proceeding. This is just a reminder for you. And we may revisit the matter again tomorrow. Thank you, Counsel. Thank you, witness. Today's hearing will be adjourned now, and it will resume tomorrow, that is the Thursday, the 6th September 2012, starting from 9 a.m. We will continue to hear the testimony of this same witness who will be questioned by Nuon Chia's defense and then by Ieng Sari's defense. This information is for the general public and for the parties. Mr. Witness, the hearing of your testimony has not yet concluded, and you are invited to once again come to the courtroom to testify tomorrow morning, and it is likely that your testimony will conclude tomorrow. Court officer, in coordination with Visual Unit, please assist the witness for his return to his residence and have him return to the courtroom tomorrow morning at 9 a.m. Security guards, you are instructed to take the three accused back to the ECCC detention facility and have them return to the courtroom tomorrow morning prior to 9 a.m. The court is now adjourned.
សូមអញ្ជើញក្រោកឈរ